Good morning. Thank you for joining us. This is a meeting of the State of New Mexico Oil Conservation Commission. Noting the time, I'd like to call the meeting to order. Sheila, would you mind calling the roll, please?
Yes, good morning. Commissioner Ampoma?
Present.
Commissioner Chang?
Present.
Commissioner Bloom?
Present.
And for our first item on the agenda, Commissioner Balin Lampkin is on the platform, I believe.
Correct, I'm here.
Great. Thank you very much. We'll proceed with Commissioner Bloom until we hit the agenda item for Empire and Goodnight consolidated cases. If I could have a motion to, if everybody has had a chance to review the agenda, if there's any debate or otherwise a motion to approve the agenda, please.
I so move. I second.
Any objection? Without objection, so adopted. Have commissioners had a chance to review the meeting minutes of the meeting from October 16th, 17th, and October 20th through November 6th, and the meeting minutes from November 13th?
Mr. Chair, I was able to review the meeting minutes from the financial assurances deliberation and just had a couple edits there.
Okay. Problem.
All right. Looking at the minutes for October 22nd, second line from the bottom that day, it says witness Morgan continued to testify. I believe that's witness Peltz because we had transitioned to the Peltz testimony, and then the next morning we took up with Adam Peltz again.
That appears, I think I concur with that. Would you mind noting the page number just so that our commission clerk can make the corrections?
Yes, and I did send these to Ms. Apodaca last night.
Oh, perfect. Okay.
That is on page 3.
Okay.
And then on page 4, fourth paragraph down, a period after my last name, Bloom. And then the final correction, suggestion, page 11, last paragraph. It says after discussion by the commission, Commissioner Bloom moved to deny the motion to dismiss. Roll call was taken. I believe there would have been a second in there.
There was, yeah.
Yeah, and we just need to determine who that was. I'm thinking it's usually Dr. Ampoma. So if we could just check and add that in, that's what we have.
Any opposition or concerns about those edits?
No, sir.
Okay. Well, in that case, I will take a motion to approve as amended.
I so move.
I second.
Without objection, so adopted. Thank you very much. With that, we can proceed to the approval of a final order on the consolidated cases for Goodnight Midstream versus Empire, New Mexico. Commission Counsel?
Just for the record, since you were last in closed session, can you attest that only the matters discussed in closed session were those ones in the original motion from last meeting?
I can so attest.
Mr. Chair, I don't know if we need to separately approve the meeting minutes from October 16th and 17th.
Oh, so let me go back to that. I had taken your motion to mean we were adopting them all, but I guess you were specific to adopting the meeting minutes for just the rulemaking hearings, right?
That's what I was thinking.
Okay, in that case, I apologize. Let me go back to agenda item number 3. Is there any edits to the October 16th and 17th meeting minutes?
I do not have any, Mr. Chair.
I do not.
Would
I
you
do
like
not
more
have
time?
any either.
So that one was a little bit complex. We had the morning session was the case that Commissioner Thompson was present. And then in the afternoon, then that was when me and Commissioner Lumpkin participated.
That's correct.
Yeah, but I do not have any edits to this.
Okay. I don't have any of these either, and I didn't notice anything inaccurate in those meeting minutes, so. Is there any objection to adopting the October 16th, 17 minutes?
No objections?
Could you just have Commissioner Poma make the motion?
I so move.
I can second, and without objection. October 16th and 17th adopted. I don't know if we've had a chance to look at the November 13th meeting minutes.
Mr. Chair, I believe Ms. Apodaca was not able to get those finished up, so we'll maybe approve those at our next meeting.
Okay, so we're gonna, I guess, table or hold in abeyance the approval of the November 13th, 2025 meeting until the next commission meeting. Okay, I think we're ready to proceed to the consolidated cases for Goodnight and Empire now. No objections? Great. In that case, we'll do a quick switcheroo of commissioners, and looks like Commissioner Lampkin is online with us. Commissioners, as I just attested earlier, we had a closed session discussion to deliberate on the Goodnight Midstream and Empire cases, consolidated cases. There was a draft order circulated. The final draft order, is there any further debate or amendments that need to be made to the order that were circulated from Commission Clerk?
Mr. Chair, I had the chance to review the final order and I do not have any edits or any concerns with it. Thank you.
Okay. Commissioner Lampkin, any further edits or concerns?
I do not have any further edits or concerns either.
Okay. Sounds good. In that case, I think we should, I'm debating whether to summarize this for parties, but I think we've got copies here to just hand out and you guys can read that in full for yourselves. So in that case, I will entertain a motion to adopt the order on the rehearing of the Goodnight Midstream and Empire cases.
Mr. Chair, I move to adapt the order that we put together denying Goodnight's applications and partially granting and partially denying Empire's applications.
Thank you very much. May I have a second?
I second.
Thank you very much. We can do why don't we, for formality's sake, if the Commissioner and Clerk would call the roll.
Commissioner Ampoma,
Approved.
Commissioner Lampkin,
Approved.
and Commissioner Chang.
Approved.
Okay.
Thank you very much. I will sign copies and distribute them in 10 seconds. Thank you very much for joining us, Commissioner Lamkin. I think the rest of these cases I will turn over to Commissioner Bloom for the SLO Commissioner slot. And I will now move on to case number 25603. Application by Matador Production Company for a de novo hearing on division order on division orders R23869 and division case number 25283-84. Are the parties with us for this case?
Good morning, Mr. Commissioner Paula Vance with the Santa Fe Office of Holland and Hart, and also my colleague Adam Rankin on behalf of Matador.
Great.
Good morning, Mr. Chair, Commissioners. Dana Hardy with Hardy McLean on behalf of Permian Resources Operating, and also with me appearing is Ms. Jacqueline McLean.
Thank you all very much. I believe the last I saw there was probably like a 2-sentence filings telling me that there was wished to be a de novo hearing, but I don't know that I don't think we actually explored what the issues were, what you might need. It sounded like from the last status conference that the parties were meeting to confer and were exploring a possible settlement. So I guess I don't know if I can open the floor to whoever wants to help me understand what the status of this case might be.
Yeah, I think at this point right now, we're prepared to move forward with a hearing. That being said, the parties still are in negotiations. And we did confer with opposing counsel yesterday about procedurally how to move forward. And I think that we both agreed that on filing testimony prior to any kind of hearing that we might have before the commission. And that, you know, I think that that was pretty much it. Handed over to Ms. Hardy.
Yes, I think that's correct. We do have a contested hearing in this case set on February 12th as a de novo hearing requested by Matador. And so we did confer, and I think the issues in the case really are whether the compulsory pooling applications of Permian Resources should be granted based on the evaluation of the 7 factors. And then Matador has a competing development plan. So I think those are the issues. And we spoke about whether we could agree on certain factors. And I think at this point, I don't think that we can. I would say that the primary factor involves the working interest percentage and control, and the overlapping acreage that's at issue between the 2 development plans. So I think that's the primary issue, but I think that the parties would want to raise potentially any of the 7 factors that the commission and division consider in compulsory pooling cases. And I think that we have agreed, if it would be helpful to the commission, to submit pre-filed written testimony with our exhibits a week before the hearing date, since that would likely, or we expect it would facilitate and expedite the hearing process.
And we agree with that. That's, you
know. This is competing operatorship for the same pool. Is that a fair characterization?
Yes. And it's limited to just 1 quarter section of overlapping contested acreage. So.
Okay.
Yes, there are competing development plans. And they overlap, not in their entirety, but partially.
Oh, I see. Okay.
And it involves a pooling application filed by Permian, and then Matador has a existing JOA covering the same acreage.
For its development.
Yes.
Okay. I don't know if the February 12th date will work if we can't hold this to a reasonable 1-day hearing. So just let me know whether the parties are able to narrow the issues so that, and narrow the list of witnesses to a point where this might be realistic to hold in a single day.
I think that we discussed and we believe that we would be able to have a 1-day, limit it to 1-day hearing, especially if we're able to do pre-filed testimony and statements from our witnesses. But possibly it could bleed over into maybe a little bit of a second day, but I think that we both agreed that we could limit it to 1 day.
Okay,
Yes.
sounds good. Why don't we still set this just for I think we've set it for February 12th at the moment. Is that correct? Okay. We have a January. I might just set this on a status conference just to check in on status of where parties are at and whether the issues have gotten any narrower or hopefully not any broader. But we'll just do a check-in with you guys at the January commission meetings just to see where everybody's at.
That sounds
Okay,
great.
that sounds perfect.
All right, thank you.
Thank you.
In that case, I will go on to our next case, which is case number 25700, application of Lily and Warren Anderson for de novo hearing on division order number 23989. Are Mr. and Ms. Lily and Warren Anderson with us on the platform? In the meantime, would you like to enter your appearance?
Good morning, Mr. Chair, Commissioners, Council Parties. Darren Savage with Aberdeen Shield, appearing on behalf of Alpha Energy Partners 2 and affiliates.
Mr. or Ms. Anderson? Are you ready are you with us?
Yes.
Okay,
Yeah.
good.
Yes, I've been here 10 minutes before the meeting started, sir.
Oh, good. Well, we can hear you now, so thank you. I appreciate it. We couldn't hear you before. So glad you're on the platform and you can hear us all right?
Yes, sir.
Great. Okay. So there are motions for summary judgments here.
Oh, and Mr. Chair, Mr. Rankin, are you representing someone here? Yes.
Oh, you also, yeah.
Good morning, Mr. Oh, I think it's because Darren, you've got your microphone on. Sorry. Good morning again. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Service in Permian, and we just entered an appearance, so we're just observing. Thank you.
Okay. We have a pending motion from Mr. Savage for summary judgment. We don't have to do oral arguments. We can certainly proceed on the filings. But given that there is a pro se party here, I wanted to offer the courtesy to all parties, even the observing ones, to see if they would like to make any oral arguments here at this hearing for or against the pending summary judgment motion.
I would like to make an oral argument
Okay.
in an opening statement.
Fair enough. Typically, the movement would go first. Mr. Savage, would you mind yielding or would you prefer to go first?
I can yield if I can have opportunity to respond.
I'm saying that again.
I said I don't mind yielding if he wants to make an opening statement and I can respond.
That's just fine. All right. In that case, Mr. Anderson, I will ask you to keep it somewhat brief. Would 10 minutes, 15 minutes be sufficient? How much time do you think you might need?
Oh, I'll be finished. I'll be brief. I don't need that much time.
Great. Okay. In that case, please go ahead. We're all ears.
Okay. My opening statement is that this is a de novo appeal. This issue before the division is not whether Alpha Energy Partners or Permian Asset Company want to develop minerals. This issue is whether the New Mexico Oil Conservation Division may approve a pooling order that results in what I think is trespass, unfair burden, and the effective loss of residential use of private property. Alpha and Permian do not have a voluntary agreement, an easement, or lawful authority to burden or access the property. Their proposal assumes operational rights that do not exist. Pooling authority under NMSA 70-2-17 is conditional. When burdens imposed outweigh protection offered, the statute does not authorize compulsory pooling. Finally, the proposed operation would block ability to place a home on the property. This is a loss of core property rights. So my argument is under MNSA 70-2-25, the division must ensure that all orders are issued after notice and hearing in a manner that protects correlate rights under 70-2-29. Any agreed party has the right to seek review and file a de novo appeal, allowing the matter to be heard anew on merits. Landowners invoke that statutory right here on grounds that the process of outcome in the prior proceedings were unfair and their rights and interests. The division owns precedent favor equitable balancing among parties. However, in this case, the weight of advantage, I believe, was towards corporate operators. Landowners therefore respectively request that this matter be reopened and reexamined under the principles of fair process, transparency, and equal treatment under the Oil and Gas Act. 4, wherefore premises considered, Warren and Lily Anderson respectfully request that the division grant plea in support of an appeal de novo filing, set aside or stay the prior order pending new review, schedule de novo hearing before a neutral examiner, requires Alpha Energy Partners and Paloma Permanent Asset Company to demonstrate compliance with fair and equitable standards and grant such further relief as justice and fairness may require. So what I'm saying is that we never, we don't mind Alpha coming onto the property, but we do mind them doing it without us being in agreement with what they're trying to do. We have no, we want to make a deal. And for the last, I believe, year and a half, we've been trying to make a deal. And I believe this is blatant thuggery, bullying, and bogarting what Alpha is doing to us. And we really don't understand it.
Okay, thank you. Commissioners, would you like to ask any questions now, or would you like to have the response from Mr. Savage before we start asking questions?
Mr. Chair, I would wait. Thank you.
Mr. Chair, I'll wait too.
Okay, in that case, I'll turn to Mr. Savage.
Thank you, Mr. Chair. As I stated in my reply to Mr. Anderson's response, the laws governing pooling, forced pooling, have been long settled, and states have a right to force pool. The division did pool the interest, including Mr. Anderson's, and Mr. Anderson provides no evidence to show that there was any bias or prejudice in those matters. So the issue boils down, and as Mr. Anderson states, that Alpha and Anderson have not been able to reach a voluntary agreement. That is the issue. There's a requirement in the rules and the statutes that the parties have to attempt to reach a voluntary agreement prior to filing a pooling application. Both as Mr. Anderson points out, the parties have been negotiating over the past year. So there's the evidence, and plus the evidence that we provided, 23 more than 23 email exchanges showing the efforts to reach an agreement. In our motion, we point out the OCC policy and what the minimal requirements are for good faith negotiations. And we point out the rules involved, and we show the evidence that all the requirements have been met, not only the email exchanges, the well proposal provided, and offers that well exceed fair market value, and certainly well exceed the default statutory royalty amount for unleased part interest. Mr. Anderson cites 72-25. This is not applicable to the assertion that he makes. That is a statute that deals with appeal to district court of a commission decision. He also cites 72-29 for his position, and that also is a misapplication of the statute that deals with the jurisdictional limitations of the Oil and Gas Act. So it looks to me that Anderson has provided no evidence whatsoever to make his case. There's been no argument over the facts. In fact, Mr. Anderson admits to the facts that they have been negotiating. So there exists no genuine issue of material facts in this matter. All facts taken in light most favorable to Anderson shows that Alpha has satisfied all requirements for good faith negotiations under the commission policy and division rules. All evidence clearly shows Alpha attempted in good faith to reach a voluntary agreement prior to pooling Anderson's interest and made excellent offers to lease Anderson that exceeded fair market value. Mr. Chair, we believe that Alpha's summary judgment should be granted. Thank you.
Thank you. I'll open the floor to any questions from commissioners.
Mr. Chair, I do not have any questions.
Mr. Chair, I do not have any questions.
Okay.
I admit that I'm from Santa Fe. I shop at Whole Foods. I live in an urban area. I do not understand the allegation that someone wants to build a house in the middle of an oil well. Can either party explain that to me?
This is Mr. Anderson. What I'm saying is, why is pooling appropriate in the first place? And I don't want an oil well there, so I can put up my residence. I don't want, and that's why we refuse to have something like that go on there on the property. It's not that I want to build a house in the middle of an oil well. I don't want to do that. And if the pooling is legal, then I mean, we just want things to be fair, period.
I'll respond since that question was directed to all parties. Mr. Anderson owns a mineral interest of 0.274582 net acres. The well location is not near in the residential area. It's not in any place where one would build a house, as I understand it. The well bore, the well is drilled away from, at appropriate site, permitted site, and the wellbore extends under the land, under the lot which Anderson happens to own. So there's no interference with his house, and then there's no interference with any construction of a residential house.
Any further questions? Okay. I have a couple of questions for Mr. Anderson here. I understand you used the word bullying, and I understand that you feel that the proceedings have not been fair to you. Can you help me better understand what led you to that conclusion, sir?
What leads me to that conclusion is that I don't necessarily understand all the laws that are going on here, but I do understand someone trying to give you a contract and saying, hey, we want to do this on your property, and then us saying, hey, no, we don't want you to do that on our property. And
I apologize, Mr. Anderson. I got distracted because we had a coffee incident here. Could you start from the beginning? I apologize. I got distracted.
oh, okay. So what I'm saying is, I just believe it's unfair, improper. The pooling terms, the pooling proposals cannot be approved because if it imposes unreasonable and excessive burden on us, including inflated overhead, expanded operators authority, restricted audit rights, weakened insurance protections. The operators control marketing, pooling must be fair, equitable, and protective towards the owners. And in this pooling application, they're asking us to pay penalties 100%, 300%. The operator has not shown that its proposal is equitable, protective, or correlative rights, or free of undue burden. No pooling order may be granted where the burdens outweigh protections or private property would be subjected to intrusive obligations without law justification. So, I mean, we're just saying we respectfully request the denial of the pooling application, and it's the way it's set up. And it's just the proposed operation would result, I believe, in trespass absent lawfully of acquired rights.
Okay. Mr. Anderson, so in I understand that the compulsory pooling, sort of the default rules in the, well, so let me back up. If parties cannot come to an agreement, then you end up in a compulsory pooling situation. You wouldn't be in a compulsory pooling proceeding if there was a voluntary pooling agreement, right? So in this
Right.
case, you were not able to come to an agreement, and I think I heard you say that you felt bullied. Can you help me give me some specific instances of some evidence I can point to as to what made you feel like you felt bullied in the process?
The thing is, I felt we felt bullied because we were saying that basically we don't understand how Alpha and Permian can just come onto the property and take our mineral rights and our surface rights. We don't necessarily understand that, and we feel bullied because if someone coming onto your property and you say no, stop, but they still continue to come onto your property and do what they want and impose stuff. And I mean, it's just, we feel it's unfair, the financial risk that they're asking us to take on. We don't have proportional protection. And this just feels like a loss of control over property interest and unequal treatment, favoring the operator. It just, I mean, that's why we don't consent. And we just feel like the owners have been violated the protective purposes of compulsory pooling statutes. I mean,
Okay. Okay, I hear you. And so let me ask another question. There was in the in Mr. Savage's filings, he attached a series of emails between you and the company's landman. Those, are those emails an accurate representation? They haven't been, or
no,
is
we've been going on a year and a half, and I don't ever remember sending that many emails. I talked to Mr. Kaufman, and I called him on some concerns, and in the latter part of 2025, they called me, but in a year and a half, I don't remember ever having that many back and forth. What I remember is we're trying to ask them questions and negotiate with them, and everything that they sent was in the wrong name, and I think that they sent it in the hope that we wouldn't get it. And but when we did get it, we did contact them. And yes, we tried to make negotiations, but they didn't try to make negotiations with us. And they're using, we feel that they're using the OCD and the OCC as really oh, if you don't agree with us, this is what's going to happen to you, and we're going to impose these penalties and other injustices on you. That's what we see.
okay. I think that's all the questions that I have. Any further questions from either commission, council, commissioners? Okay. In that case, go ahead.
At this point, are we ready to deliberate on this, or where are we at, Mr. Chair?
I think we're, I think we're probably ready to deliberate based on all of the filings and the discussions that we just had today. In the interest of not keeping Mr. Savage waiting while we go into closed session, I would ask the commission whether we would like to proceed to also just the rest of the cases so that we can let all the councils go home and deliberate on all the pending cases in front of us today all at once. Or, I mean, if commission wishes to go into closed session to deliberate on this case and then come back and hear the rest, that's well within its powers as well.
Mr. Chair, I might like to deliberate in closed session on this case and the other, I guess, three now one conjoined case that we have in front of us with Alpha and AER.
Together? Or?
Yes.
Okay.
Yes.
In that case, thank you all very much on the Anderson case. We are going to deliberate on that later today. And for now, during the hearing, for the purposes of the hearing, we will move on to the next consolidated cases. Well, I don't know if they're actually consolidated, but we're going to hear them as if they're consolidated anyway, I think. That's going to be case. So thank you, Mr. Anderson, and we'll go through all of the filings and deliberate, and we'll get a decision out. It might not be until the next commission meeting that we're able to hold a formal vote and issue an actual written decision. But thank you very much for participating.
Yeah, thank you, sir. I thank you for having me. Thank you.
Thank you. All right. So moving on to case number 25694, 25695, and 25696. Are all the parties with us? And if so, could I get your entries of appearances?
Good morning, Mr. Chair, Commissioners, Council, parties. Darren Savage with Abity Shield, appearing on behalf of Alpha Energy Partners 2 and affiliates.
Good morning, Mr. Commissioner and panel. Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Permian Resources Operating LLC, Service Permian Land Fund 1 LLC, U.S. Energy Development Corporation, and Service Rockmont Permian Land Fund LLC. Sorry, and that was the same for the last case as well. Thank you. And we are just observing.
Jonathan Samaniego, American Energy Resources.
Great. Thank you very much. I'm glad. And you can hear us all right on the platform? Mr. Samaniego, can you hear us all right?
Yes, sir.
Great. Okay. All right. We've got a whole flurry of motions, including stuff that we received only last night. So again, I think the commission is again at a bit of a disadvantage in terms of just having enough time to have reviewed all of the materials. So I'm not sure how best to proceed at this point, but Mr. Samaniego, since it's your application, could you give the commission an update on where we're at and how the commission can best move forward on, or how you would like the commission to move forward with the flurry of, with the underlying case as well as the various pending motions?
Well, the appropriate way for the commission to move forward on the orders that Alpha was given. Let me pull those up. Orders 23961, 23977, 23989. Under the terms of the order shall automatically terminate. Automatically. It's very specific in the orders. Automatically terminate upon failure of the applicant to give notice. And it is clear and also evident that the applicant failed at his obligated duties as an operator, and under the terms, it would be appropriate for all three orders to be automatically terminated under the terms of the orders. Next is the overlapping title dispute, okay, that it's clear the applicant cannot prevail. And also the infringement and trespass of an existing unit without approval and notice. And under 1915-16 MAC, it is proper to get the approval of the operator of an existing unit. And because of these reasons, and I'm not even going to get into the malice twisting of law, but it's clear a lot was done. A lot of deception by the applicant, where they can't prevail. And also, the applicant does not have adequate financial assurances to operate, so I don't believe that they even have a right to speak on their behalf today, because they are not, they are an imprudent operator. They do not have adequate financial assurances. They've been very, intentionally deceived the commission and the division through their erroneous applicant, and trespass and infringe on collective rights. I mean, every step of the way, it's been continually fraudulent.
Okay.
And for the commission to allow them to move forward in any manner would be so appropriate and a violation of your obligated duties to protect core elective rights and prevent waste. So it contradicts what your duties are by allowing them to proceed.
We hear you, Mr. Samaniego, thank you. Before I give, let me ask a question because I think this might help a little bit. First, I'm trying to figure out the basis of standing and jurisdiction to begin with, the threshold issue here. There was a dispute as to title. So what is the claim here, Mr. Samaniego? I understand that there is a well in question, right? I'm not sure how it's pronounced, Sake well or Sike well. That particular well that you have at least made the claim that you operate, right? Now, do you also have title to minerals in the area being pooled?
And I find that troubling because all of this should have been reviewed by the commission members prior to this hearing, and you haven't even seen my title that I've submitted with my evidence.
So you claim, no, well, I'm asking you the questions because I can't testify on your behalf, right? So I'm trying to give you the opportunity to put on the record for our transcriber here the facts that you believe favor you, right? So work with me. So if you can help me here. You believe you have title to, you believe that you not only have a operatorship, but you believe you have minerals. Is that accurate?
I own both in the area. I'm a leaseholder and a mineral owner.
Right. Okay. Okay. All right. Fair. So then let me turn to Mr. Savage here, because it seems to me like we've got a legitimate title dispute that is going to be a gateway issue for whether or not Mr. Samaniego has standing to bring the suit, because if he does have title, then he was entitled to notice, which I believe, and correct me if I'm wrong, but I don't believe he was actually noticed. But if he doesn't have mineral title, then he wouldn't, then there wouldn't be standing to bring the suit at all, right?
If it was mineral title, I'd be in the position like,
hang on, Mr. Samaniego, I'll let you respond, but I addressed that question to Mr. Savage first. So I'll ask Mr. Savage and I'll let you respond, okay?
So, American Energy Resources had, for some reason, had been granted approval of operatorship of the Sake well in January 2025. He had received an assignment of what we view as expired leases because those lessors have now executed new leases. Those were leases from the 1960s. And you know, that was he received those leases about eight years ago, or 7 years ago in 2018. And then he appeared, made an entry of appearance into the underlying OCD hearing and participated in the hearing, and all his objections were heard and due process was served. The question is, I mean, our concern, or our main concern in this is the request for a motion to stay that he has filed. That would be very disruptive, and we do not believe there is that he has shown argumentation to prevail on the stay. The title issue, the OCD, the OCC does not have jurisdiction to adjudicate title, but there's a number of other issues, as you know, OCC counsel has brought up, such as the status of the Sake well. The Sake well is in the subject lands. it's in with that Alpha wants to develop. So I guess the question is, does the OCC want to bundle up all those issues and defer to district court because they include a title dispute, or does the OCC want to segregate the title dispute from the other remaining issues that very well would resolve this controversy? And one of the motions that we provided was a request for an evidentiary hearing to determine whether those lake wells should be plugged. And there's plenty of evidence to show that this is a non-producing and orphaned well. So I don't know how the OCC wants to proceed on these matters.
I will let you respond now, Mr. Samaniego, but just keep it brief because I do have further follow-up questions that I think I would like both of you to answer.
American Energy to date has not received an NOV letter from regulatory at the division. The fact that Alpha's counsel continues to repeat this false representation is arbitrary and erroneous. To date, there has been no violation sent to American by the division. American has adequate financial assurances, is operating within the laws of New Mexico, and is a prudent operator. Alpha, on the other hand, has violated core elective rights, has deceived the compulsory pooling process, does not have adequate financial assurances, and has 4 abandoned wells, one which sits right next to Walmart. The other 3 are throughout the town, within the public, and an effect on public health and the environment within city limits. And the division continues it goes through one ear and out the other onto why hasn't regulatory handled Alpha's violations. And for an imprudent operator such as Alpha to continually repeating this phrase as some tired out parrot, okay, is false representation. It's deception at its best.
Okay.
And it has no place of standing as an operator who's supposed to be operated on an honor system and is here to give deception to the division and commission for ill intentions and financial gains.
Mr. Savage and Mr. Samaniego, let me help try to steer the conversation to where.
Mr. Chair, may I just add one more point regarding the jurisdictional matter? The commission may want to consider that Mr. AER, American Energy Resources, is not being pooled. They are not being pooled. They were not listed as a party to be pulled because Alpha considers that they don't have sees that as confirmed that they don't have any interest. So they're not subject to this pooling order.
Objection.
And that is really an excellent basis for that American Energy Resources does not have standing to appeal the pooling order.
Objection.
If they're not subject to the pooling order, then they feel like their property rights are being violated, that truly is a matter for district court. So on that basis, yes, you could say he does not have standing at this point because he's not subject to the pooling order, and you could proceed under that.
So I want to give Mr. Samaniego a chance to respond here because I think that's where you guys are starting to understand my question here, which is a gateway issue. The gateway issue of I don't want to argue about whether or not you guys think each other are wonderful or terrible operators. I'm sure you both have a strong, well, I already know that you both have strong opinions on that, and we don't need to repeat that. But I don't think we can even get there because we can't get there yet until I can establish whether or not, Mr. Samaniego, you've got some sort of sufficient interest that gives you a standing for us to even hear this case. Because if this is a purely title issue, like Mr. Samaniego, you and I, we've had this conversation about other cases where the proper venue, not that I'm not weighing into whether or not any of your substantive concerns are valid or invalid. At this point, I just want to make sure that you are in the right forum for the right dispute. So the
I'm
question
trying to
is,
explain.
yeah, so go ahead and if you want to respond to what Mr. Savage just said.
Okay, yes, because he's been antagonizing me with argument that leads me astray from my defense.
Well,
and
let me help you come back then.
and that's a good Camilla Harris trick, but he's not Camilla Harris. Okay, to get somebody rambled on in a different direction, it's so Camilla Harris. So as I like to present is that under the leases that he presented, Bell and Willer leases, okay, there's a clause in there that any default by one shall not affect the rights of another. Meaning, whatever default or violation Wildcat had, that's on Wildcat. When American obtained the leases, it fell within the 90 days that it sent out checks, that it put out a publication, and it corrected the violations from continuing. Within the 90 days clause, American did that. Latches comes into play because a previous operator defaults do not have no effect on the new operator. It's like it restarts again. So American is protected through latches. The fact that Mr. Savage continues to try to move this forward erroneously when in fact under the clauses of the leases, American is protected. On a second note is that Enterprise, the gas purchaser out there in the area, they failed to fix those gas lines. I have emails with Enterprise of them stating there's leaks in those lines. I was not going to send gas down those lines with it leaking. Okay, and under the terms of the leases, American is protected because it is of no fault of its own. I had no effect in holes getting in an imprudent gas purchaser's sales lines.
So let me bring you back again.
And coincidentally, they cap it right during my hearings. And take note, Enterprise is flipping the bill of that compressor station that's being built for Alpha. They got financial gains in the matter. So if you go on it, it becomes under discrimination of price discrimination because they're choosing one operator over another.
I understand that there are many upsetting issues.
American leases are not terminated under the terms of the leases. The fact that Savage continues to ramble a false representation of terminated leases and not pulling Americans' interest and Americans not being pulled is deception at its grossest.
Okay, so that, again, you're getting ahead of me here. I'm just trying to figure out because if I understand correctly, you were not part of the interest being pooled in the underlying order. So I want to figure out I think I've said enough, but I'm going to invite Ms. Vance or Mr. Rankin to perhaps weigh in here as the third party.
Thank you, Chair Chang, Commissioners. I appreciate the dialogue and discourse on this. We represent interests in this case, in these cases that are have mineral interests and leasehold interests, and their primary interest is seeing the property developed and their economic investments realized. Under the compulsory pooling statutes and the regulations that promulgate those statutes, as Mr. Savage alluded to, under the regulations, applicants for compulsory pooling are required to give notice to each owner of an interest in the mineral estate of the lands that the applicant proposes to be pooled. So if, as is the case here, that Alpha is not seeking to pool the interest because it does not believe it has a title or any interest to be pooled, they are not subject to the pooling, nor will they be disadvantaged by the pooling. If American Energy Enterprise believes that they nevertheless are do have title and a leasehold interest and mineral interest, the statute protects them. The Oil and Gas Act does protect them because if they are able to prove through quiet title action that they do have an interest, then they have the ability to pursue those rights through the courts. And Alpha, by not pooling, or recognize the title does so at their own risk. And so if there's an opportunity or proof that American actually does own an interest under the New Mexico Proceeds Payment Act, it's possible that American Energy could go after Alpha and claim, back attorney's fees, interests, other aspects if they're not being paid appropriately. So there's avenues for American to pursue that probably are more appropriate given the nature of the dispute being based in title. I have not read the briefing, so I don't have the benefit of understanding all the arguments, but just listening to the discussion today, I thought this might be helpful to give some context. And I'm sure Mr. Savage and Mr. Samaniego may want to respond to better articulate how what I have to say fits into each party's arguments. But just on a base level, hearing Chair Chang raise the issue about the threshold gate issue, I believe that having not established title, or if there is a title question indeed, then I think probably the venue is not appropriate. But I'll let Mr. Savage respond.
Let me just give Mr. Samaniego his turn, and then we'll turn to you, Mr. Savage. Mr. Samaniego?
Yes, Mr. Rankin, his claim is a personal opinion, and he said it was his own basis. He even admitted that he did not review. So the fact that he's offering a quiet title to resolve Americans' claims is premature and irrelevant, because in the exhibits, American presented his title, American presented his claim, and American has standing from infringement and trespass.
Mr. Savage?
So, as I mentioned, Alpha's main concern is this claim to an emergency stay. So, since American Energy Resources is not being pooled, and that the commission can address the standing issue on that basis and determine that he does not have standing and that the matter should go to district court, then as I understand that, there would be no basis on which to request a stay, and the commission can rule on that. Yes.
Objection.
Thank you.
Go ahead.
Go ahead, Mr. Samaniego.
Yes, I find it very improper that Savage keeps on, like a broken record, he just keeps on repeating, and the fact that he continues that they're not pulling American interest is far from the truth. And for the commission to go say, okay, it could be wrong, go ahead and do it, it's going to cause more severe harm on American to have to fight those claims. So I think that it would be appropriate and responsible for the commission to proceed with caution and to see that allowing anybody to proceed in this manner of infringement and trespass, okay, is not the protection of core elective rights. It's sweeping it under the rug. And that's not appropriate, and it's not appropriate. That's a violation of the obligated duties.
Okay, I hear you. Let me turn now to commission and commission counsel and see if there are any additional questions that commissioners or commission counsel wish to explore.
Mr. Chair, I had a couple questions.
Please.
Mr. Samaniego, good morning.
Good morning.
I'd like to ask you a couple questions about the sake well or the psych well. How did you measure production out there?
That's not the topic of this hearing. Well, the hearing is to see if the emergency stay is going to proceed, and to see if Americans' interests were valid or not valid. Under the presented evidence, American has fulfilled its duties by presenting its exhibits as evidence, its title, its claims, with emails, and American has fulfilled its duties to present to this hearing on why the emergency stay should be granted. Anything outside that realm is inappropriate and it's irrelevant here.
Mr. Samaniego, you mentioned it in your writings. and you've claimed that it's a producing well. So we need to explore that. So I'm going to ask
Again,
you, how was production measured?
You're twisting words. I filed under producing testing. Okay, so you're playing with words, and that's why I'm not going to get into that. I'm not going to fall into that because it's irrelevant here of what this hearing was for. American presented his title. American does not have to go through quiet title like Rankin prematurely, his personal opinion. American presented title. It's an overlapping title dispute, and the applicant cannot prevail under the terms of the leases. It's clear. It's in black and white. It's clear evidence.
Some of the ways we look at this case could, Mr. Samaniego, be based on the status of this well.
Well, a jury would look at it differently.
You're in front of the Oil Conservation Commission, sir. You're not in front of a jury here.
Right, and that's what I'm saying. It's appropriate to go ahead and allow the emergency stay to protect all core elective rights and allow them to proceed through district court because it's out of your jurisdiction. And any attempt for the commission to tailor make an evaluation of an overlapping dispute in title is a violation of your obligated duties to protect core elective rights and to prevent waste because you're unsure and you can't guarantee that your action will protect. You can't guarantee it.
Mr. Samaniego, you mentioned that Enterprise has a system near the Psych well.
Can you repeat?
You mentioned, sir, that Enterprise has a pipeline to the Psych well. Is that correct?
That's not what we're here for.
Well, you brought it up within the last 20 minutes.
Yes, that Enterprise is an imprudent gas purchaser with personal agendas with other operators in the area.
Does Enterprise have to fix a line? Do they have to service you?
It's their obligated duty. And because they have that easement, they have bonds put up for those lines with the division. And the fact that the division is not regulating those pipelines with those bonds, that's erroneous. These pipeline companies out there need to clean up all those lines. The 75% of those lines are all dead with holes out there. Holes everywhere. That's why DCP is dumping them. And those guys like Enterprise are picking them up. And then they're not even fixing them. Imprudent operator of a gas purchaser.
Mr. Samaniego, you also mentioned that you're reporting 1 MCF of production out there. What happened to that gas?
We're not going to get into that because that's not part of what this hearing is for.
Was it flared? Was it vented?
We're not going to get into that because that's not what this hearing is for.
Mr. Chair, I have no further questions.
Any further questions from any other commissioners or commission counsel?
I do have only one.
Please.
So, Mr. Samaniego, I do have a quick question for you. So I just want to know, on the basis that you would like the commission to grant a stay, if, let's say, we've not, as I sit here, I'm not sure if you've established that you do have standing.
You didn't establish that I had standing in the prior hearing when you prematurely offered to rip off the Band-Aid or rip off the scab. I don't know how you referenced it, but at that time you were premature. So given that you've already been prematurely giving options, makes your statement compromised today.
Okay. Any Ms. Vance or Mr. Rankin, any last words?
Nothing further.
Okay. Well, in that case, if unless there's anything further from anybody, I think we'll take the matter in, and we'll head into deliberations, into closed sessions to deliberate on, let me just get the cases correct here, on the, on case number 25700, 25694, 25695, and 25696. May I get a motion to go into closed session for deliberations on these 4 cases?
Chair, one moment. Yes, Mr. Chair, I so move.
Second.
I believe we need a roll call. Ms. Apodaca, may we have a roll call?
Okay. Commissioner Bloom? You approve?
Yes.
Okay. Commissioner Ampoma, do you approve?
Approved, yeah.
And Commissioner Chang?
Yes.
Okay.
Without objection, we're going to head into executive session. Thank you all very much for your time and time and attention today. We appreciate it, everybody. Thank you, Mr. Semeniego. We'll get back to you with a decision. It may not be until the next commission meeting that we're able to come out and vote something, just so you know, but we'll do our best to get everybody a timely decision.
Thank you.
Thank you.
Thank you.